Hello สวัสดีครับ Good morning
Hello, how you
there.
doing, Marcus?
Good. So it's 11 a.m. at Kuala Lumpur and 10 a.m. at Bangkok. So we are so glad to bring you guys to Thailand to explore how to protect your intellectual property assets in Thailand. Yeah. So before we introduce our distinguished speaker, let's share the talk to more people. Yeah. Okay. All right. So if you have interested friends who wants to watch this webinar, we are currently live on Facebook. Okay. So you can just follow facebook.com/nbsny or share the QR code so they can watch the live video on the NBS Facebook page. Or if they would like to join the Zoom webinar and ask questions here, please type the webinar ID 93213794251 and the password 792481 to join this Zoom webinar immediately. Yeah, so I'll give you some time to screen cap and share this QR code and the webinar ID and password. Yeah. All right, done sharing? Okay, so we are really happy to have Professor Kritipat Nabangsang with us. He's the Director of Intellectual Property at RWT International Law Office. Yeah, and I'm Marcus. I'll be the host for the webinar today. Let me introduce Professor Kritipat further. Wow, he has a really long and nice profile. He has 2 bachelor's degree, one from Boston College and the other from Ramkhamhaeng University, Thailand. Yeah, and when he first started his job, he was a legal officer at the Department of Intellectual Property, right, Professor Kritipat? And then he obtained his master's degree in IP at Boston College. And then now he's also a law professor at Prince of Songkhla University. That's a huge profile. Okay.
Thank you.
Yeah. So, Professor Kritipat, we've seen Thailand, the government is really actively promoting tourism in Thailand. Thailand has nice people, beautiful landscape, and good food, right? Everyone know Thai food is ranked one of the top preferred food in the world. So what about the IP landscape in Thailand? Is it actively promoted by the government, like for businesses to protect their IP? For example, many of our clients, they're actually afraid to export or import their goods or products without registering their trademark or patents in certain countries. What about the scenario in Thailand? Is it more advisable to do that?
Actually, there's no problem with the unregistered mark as
Mm-hmm.
long as your mark is not a counterfeit product or
Mm-hmm.
is not identical or similar to the registered mark.
Mm-hmm. So if the trademark is not registered,
You
yeah,
can
for
import.
example,
It will be fine.
oh, it will be fine. So there wouldn't be any problems with the customs. Hello? Okay, we have some frozen screen. Yeah, can you hear me, Professor? So what you
All
mean is
right,
that,
did you hear me,
yeah,
Marcus?
yeah, you were frozen for a while. If
Okay.
so, if a trademark is not registered, would there be any problem at the custom? Not really. Can you hear me?
There will be no problem with the unregistered mark as long as your mark is not contained with the counterfeit good or identical or similar to the registered mark.
Okay. So do the customs do any check on infringing goods going into Thailand?
They constantly check. They not check for all of the container. If they pick and they're not sure that the good is the authentic or the counterfeit good, they're gonna call the representative. And we have a duty to identify whether it's authentic or counterfeit good.
Okay. So for them to check, you actually have to register with them. Is that so?
It's called the recognition is just you just tell them that you are the representative of the brand. That's all.
Oh.
The database of the Department of Property and the recognition of the custom is to each other.
Sorry, Professor. Can you repeat a little bit? Your line is breaking.
Okay, no problem. Actually, when they found the counterfeit or the authentic good, they're gonna notice the representative.
Okay.
Yeah, to identify that whether it's the authentic or it's counterfeit product. For the recordation, you just record that you are the representative of the brand. And the database of the Department of Intellectual Property and the custom is not related to each other.
I see. Nice. Okay. What about language? We know the national language of Thailand is Thai, right? So Thai is, I like Thai language. It's very soft and very polite language.
Okay.
And so in countries like China, yeah. So if we were to register a foreign mark, it's better to have a Chinese word. To register in China. What about Thailand?
Okay, it's recommendable to file the Thai language in Thai language because even though the trademark law is protect the similarity of the mark, it's including the pronunciation as well. But if you file the application in Thai, it's gonna enhance the chance of success.
Oh, so with the
Because
Thai language, higher success chance.
Yeah. But just to be noted that if you file in Thai language and the interested person can file the cancellation based on the non-use cancellation. If you not use that mark within like 3 years.
So after you file, you have to use it within 3 years.
Yeah.
So non-use more than 3 years can be cancelled by third party. Oh, so what is McDonald's called in Thailand, Thai language? How do you call McDonald's?
Actually, we call in Thai pronunciation we call McDonald.
McDonald. Starbucks?
Yeah, we can translate in Thai like McDonald. We have the same. We have our own pronunciation, like.
I see. Okay, what about Starbucks?
It's a little bit different from the real English language.
Okay. How do you call Starbucks in Thai? Hello.
Do you hear me?
Professor? Yeah.
Sa. Hello.
Yeah. The line broke a little bit.
Yeah, we call Sa Starbucks in Thai. Oh, okay. instead of Starbucks.
Again, what is it called again?
Starbucks.
Satabak. Satabak. Is that correct?
Yeah, yeah. The pronoun is a little bit higher.
It's difficult. Okay.
Yeah,
So,
difficult.
yeah. So without further delay, let's start our talk. Yeah. So Professor Kiripat, you may now share your screen and
Sure.
share with the audience.
All right. Okay. This is my slide. So do you see my slide, Marcus?
Okay. You may begin. The floor is yours.
All right. Okay. Good to go. Thank you, Marcus, for the perfect introductions. And today I would like to share with you the Thai regulation, and we are become a member of the Hague Agreement. So we have a lot of amendment of the Thai patent, and I think it will be effective probably 2022. Today I'm gonna share with you the draft amendment to the Thai Patent Act. As you may know, that nowadays is a lot of new innovation, and for the current law, we has been applied for 40 years. We try to amend the law up to date. Second, we're gonna comparison the direct filing versus the Madrid Protocol. We're gonna compare for the pro and con for the Madrid Protocol and direct filing. And thirdly, I'm gonna point out the problematic for the Thai trademark legislation. Why the procedure is take times. Why the office action have unclear for the specification from the trademark register. And the last topic is the enforcement procedure in Thailand. What or which authority that you have to contact with if you file the counterfeit product. First, we're gonna go for the draft amendment to the Thai Patent Act. So for the current Patent Act, we only have one publication, but for the draft, we have 2 rounds of publication. First is 18 months from the filing date. Second publication will be after the substantive examination. So you can file the opposition 90 days from the second publication. And we have a time reduction for the substantive examination of the patent. Under the current law, we have to file the substantive examination in 5 years from the publication date. But for the new law, the time is more reduced to 3 years from filing date. And as for the divisional application, for the current law, the law is not allowed the applicant to file the separation of the patent application voluntarily. But for the current law, the applicant can file voluntarily for the such request before the second publication. For the converse of the patent, like patent to utility model or utility model to the patent, the patent application can be converted to utility model within 3 years from filing date under the current law. Under the new law. Also, the conversion from the utility model to the patent application will be applied in this matter. We also have the extension of the deadline. We increase the deadline to pay the annual fee from 100 to 180 days with 30% surcharge. We also extend the deadline to file the appeal to the patent court, to the patent board. Will decrease from 60 days to 180 days. We also adding the compulsory license in the term of the import and export. Ministry now can use the license to produce and export to the least developed country or to the country to be a member of the WTO, the WTO regulations. We also, the current law, we have license agreement that have to be registration with the patent office, but under the current law, only the regulation is required. Also, the new law we cover the surgery method for the treatment of the human and animals. And we also extend for the protection for the industrial design. For the current, we have 10-year protection, but for under the new law, we have extend to 15 years protection for the industrial design. When you file the application, you have protection in 5 years, and you have to renew for the twice, 1 to 5, 6 to 10, and 10 to 15. So I'm gonna show you the flow chart that comparison between the current and the draft. For the current, after you file the application, your invention gonna get the formality check, and then publication, and you have, as I mentioned, you have to request for the examination within 5 years from the date of publication. So if no request, your invention will consider as an abandonment. And after you request, you're gonna get the substantive examination, and if the invention is good in order, your patent is gonna get the registrations. But for the draft, for the new law, once you file the application, you're gonna get the same formality examination, but you're gonna get the publication within 18 months from the date of filing for the first publication. And then you have to request for the substantive examination within 3 years from the date of filing. But for the current law, you have to file the substantive examination within 5 years from the publication date. So the time is more faster for the draft. And you're gonna get the substantive examination and second publication. Some interested person or anyone can file the opposition within 90 days, and if thing is okay, it's smooth, your patent gonna get registration. Also, the flowchart of the industrial design procedure in Thailand. they try to, the new law try to have the applicant more convenient for the payment. As you can see on the left is once you file the application, you're gonna get formality check, publication, and substantive examination and grant. So you have to pay for the three payment. You have three payment to pay. First is filing fees, and second is publication fees, and the grant fees. So it's quite inconvenient for the applicant to pay for the three times. Under the draft, you only have to pay for one-time payment since you filing the application. It includes the filing, publication, and registration fees. And you're gonna get formality check, substantive examination, publication of the application, and grant. The difference between the current and draft is under the draft, you will get substantive examination before publication. It made the process more faster than the current act. So under the draft, the claim is not necessary anymore. You don't need to have the claim under the new law, and only 6 drawing or 6 picture that you have to file with the patent office. Instead of the current law, it's must to file the application with 7 pictures, and eventually we can the applicant can file the partial design, because the current the patent office is not accept for the partial design, but under the draft we can finally. Also, for the cancellation of the industrial design, usually any cancellation is go directly to the court, but for the proposed draft, if you file the cancellation based on lack of novelty, so you have to file with the Department of Intellectual Property first, and then if the decision is unsatisfied, you can file to the court. This is the Thai patent statistic chart I get from the website of Department of Intellectual Property in Thailand. As you can see that they have a Thai application for the invention is approximately 1,000 applications filed by Thai, and approximately 7,000 filed as a foreign application. But for the industrial design, we have more Thai application rather than the foreign application. We have application filed by Thai in 2014 at 2,806, and for the 2018 is increasing to 4,043. That is the reason why we have extend protection of the industrial design from 10 years to 15 years. So now I'm gonna point out for the versus direct filing. So the advantage for when you file the merit is you can file one application, and you just have a checklist to the designated country that you would like to protect. So it's more convenient than the direct filing, which you have to contact with the local individual country to file the application for you. And for the payment, you can pay the official fee through the one centralized window. So it's like one-time payment. Like if you compare with the direct filing, you have to pay for the filing, you have to pay for the publication, and you have to pay for the registration fees. And it's more for the Madrid protocol. It's more cost effective, as you can see, it's one payment. You don't need the local firm to file the application for you. Also, the list document is required. When you file the direct filing, you have to appoint the legal representative. So you need the power of attorney in each country you have to protect. So it's going to be a lot of document that the applicant to sign, and some country they also require for the naturalization. Some country they need the legalization. It's going to take time for that. Also the record subsequent change and to renew the international registration through a single procedure step. So when you change the address of the ownership or the name of the ownership, you can file just one time to the International Bureau of the WIPO. You don't need to instruct to the local representative to change the ownership or change the address for you. As for the disadvantage, when you file the application, you're gonna send out to IB, and the IB gonna send to the each country, which each individual decision on the territory. You train out. Some country don't. The international application will be treated as a basic application. Your basic application, you has a huge problem. You have to pay local agent if the trademark issue to national registration. So you have to pay for double price. Also, the list of goods, the national application cannot be brought. You have to file the international application based on the list of goods that you file in your country in the basic application. You cannot have a broader list of goods. Also, on the registration during first 5 years. So if your application, your basic application that you if it's trademark register or it has been cancellation or invalidation, you in Thailand. So the time frame for the maybe the trademark and petition are because when you file the application based of good, so it's easy for the trademark register to instruct to have your specification more specific. It will not be a problem on the suggestion on the indicate in the office action, like Madrid protocol. For the disadvantage, as I mentioned, translation is required. We may charge you for the additional cost for the translation. Also, the notarization is required. Sometimes when you have a mother company and you have to transfer the right to your subsidiary company, you have to sign it, and it's required for the notarization as well. Maybe it's going to be take too long for verify the document. So the problem of the trademark registration. So for the Madrid trademark register, they have the lack of the English proficiency. They have difficult to translate from English to Thai. Sometimes they issue the instruction which is not too clear on the list of goods, and sometimes they have a too broad interpretation of the mark. Sometimes it's not distinctive, but the mark is just suggestive, but they think it's direct reference to the specification of good. Also, we not have enough manpower. We have 50,000 pending case for the new application as a backlog for 2020. And also we have 8,000 appeals for the trademark board to examination. And sometimes they issue the office action. Some trademark legislators, they confuse on their own instruction. The mistake about the specific, they have issues for different classes. So we also do our firm, we do market surveys, online sightseeing, test purchase, and in-depth investigation and rate action as well. So the authority that we filed a petition to assist us is the local police department, economic crime suppression division, or I call ECD, and the Department of Special Investigation. So we have a training for the custom twice a year, and once the custom found the counterfeit product, they're gonna notice for the representative, and we have a duty to identify whether the such good is the authentic or it's counterfeit product. So we have 7 to 10 days to file the verification to the custom. But in practice, you can spend one month and file the complaint to the custom. If no complaint has been filed, such good will go back to the seller. But if the complaint filed within the time period, such good will eliminated by the government. As for the ECD that I mentioned, so the advantage for the ECD and local police is ECD have their own IP department, so they have a specialty of the IP, and they have authority cover in all city in Thailand. Um, the process is when you file the petition, including the power attorney, and you have to file the investigation report, and ECD will have a decision on your investigation report whether it should be accept or not. If it accept, the ECD will file the request to the court to have to issue a search warrant. So when we go to the red action, we have to go with the police, that because as a legal representative, we have to verify that the good is real or fake. As for the DSI, Department of the Special, they have more specialty than all local police and economic crime suppression division. But they just accept for the special case only, such as, for instance, we have a Botox case. We send our investigator to the clinic, and we not just found only a fake logo. They refill the Botox with the saline. So as a result, it's gonna be effect to the public. So in that event, the DSI will involve for this case, because it may be heard for the public and it may be heard to the life. Yeah, this is the other thing that I mentioned for today. And Marcus, do you have any inquiry or question? Is this
Thank
matter?
you very much for sharing, Professor.
Sure.
Right. Yeah. So Thailand has been revamping their laws, right, on patent industrial design. What about trademark? Are they revamping the laws as well?
We just meant like 4 or 5 years ago, we add the sound mark for the new
Sound
law.
mark, non-traditional mark. Oh, I see.
Yeah, yeah.
So,
And
okay, so we can see for industrial design, the term of protection has been extended from 10 to 15 years.
yes.
Then how do you renew it? You renew it every year? Do you pay renewal fee every year, or?
For the new law, you can renew in the first payment is when you're filing 1 to 5, and for the second is 6 to 10. Third time is 11 to 15.
Oh, so 5 years each time.
Yeah.
So you can renew 2 times for 5 years.
Yeah.
Oh, okay. So, but then they have to pay the fees upfront. Is it expensive compared to breaking down the fees? Pay upfront.
Actually, is a little bit reduction for the fee.
Oh.
Yeah. Also, under the new law, the fee for filing the invention patent and industrial design is more expensive. We increase the government fee.
I see. Okay. All right. And you mentioned there is a for national filing, right? Direct filing. For example, trademark in Thailand, there is this notarization of documents, right?
Yes.
Or of attorney, or priority documents for patents. So it's kind of inconvenient for the applicants to get documents notarized, right, by the notary public. Is there any intention by the government to remove this procedure?
Honestly, the light at the end of the tunnel yet. We don't plan for the get rid of the notarization yet.
Uh-huh.
It's gonna be a while.
Okay, because quite a number of countries have done away with this.
Yeah, because I'm not sure that Malaysia for the trademark, Malaysia and Singapore now is doesn't require for the power of attorney, right?
Yeah, we don't.
Okay, it's quite convenient.
Yeah. But just now you mentioned some problems with the Thai registration, like it's quite long. We notice sometimes the trademark is quite long and we receive some office action.
Yes.
Quite easily we get office action. Just now you mentioned what mistakenly issue office action or
Sometimes they issue for the specification, but they have suggestion in the wrong list of good. You know.
Oh, I see. So
And
how do you normally overcome this?
Actually, I just call them and you have a mistake of issue of the office action, and can you amend it for us?
This kind of things cause delay, right, to the registration?
Yeah, it's called delay. They're gonna issue like you're gonna get more 60 days to file this one back to the trademark office.
I see. So it's better to call them instead of writing letters.
No, the writing letter is not effective. I think it's gonna be take time more than you calling for the direct call to the trademark register in charge of the application.
I see. And does the same goes for pattern and design? I mean, do you get similar problems?
More easier, because sometimes they're not clear what are we writing about the term of the invention. We just call it and clarify them, but most of the patent application we have to clarify by writing instead of just verbally.
I see. So you write a letter and call at the same time, right? To be professional.
Yeah. But most of the time is calling.
Yeah. Yeah, maybe. Yeah. We have to do things differently, right?
Yeah.
Okay. So let's check if there's any other questions from the participants.
All right.
Okay. Oh, yeah. One of the question is that just now you mentioned under the new law, right, for industrial design, for 3D reproduction, 6 pictures are acceptable. 6 pictures. So what about things like 2D for patterns? You know, motifs.
2D?
Yeah. Is 1 picture enough?
No. It's required 6 picture perspective, front and back and left and right, above and below. It's still required.
Okay, but
At
what about
least six picture.
okay, but what about motifs like your pillowcase? Let me show you something like this.
All right.
Okay, let's say you have motif like this, right? It's a motif, right?
Okay.
Yeah. So it's not 3D. It's not an object. It's a motif, maybe for a pillowcase or something. So do you still need 6 pictures or what? Like patterns like this.
Excuse me. The connection is lost.
Not the structure. Yeah, like this. Like these patterns. Yeah. It only has one surface.
Marcus. Sorry, the connection is lost. Can you repeat your inquiry?
If you have motifs like this, it only has one surface, the pattern, the design. Yeah.
Okay.
So it doesn't have other surfaces, only one surface. So do you still need 6 pictures of that?
But for the hair agreement, I think I'm not sure. Only one picture is sufficient. But for the new law, we only one drawing or one picture is not sufficient.
Okay, okay. So maybe for a repeated motifs or patterns, we have to give like few parts of it, right?
Yes. Yes.
Okay, okay. Any other questions from the floor? Let's see. From Facebook. Okay, no other question. Right. So thank you very much, Professor Kritipat, for your beautiful sharing with us this morning. We're really happy to have you. And also thank you very much to the audience for attending our talk. We wish you guys a happy and nice Friday. Have a good weekend ahead. Yeah. So our talk has come to an end. Thank you very much once again to our speaker. Good day.
Thank you so much, Marcus.
All right. Bye-bye.
Bye. Have a good one.
Have a good one.
Bye.